run through the
Okay,
agenda.
so the first thing the agenda is, who are you dealing with? That is maybe clearer when you're doing what Joe does, defending people against government. It may not be clear on who the actual individuals are, but who the entity is when you're doing agency work. Sometimes even the FDA is divided up so many different ways, if it's tobacco, if it's food, if it's medical device, and you need to be clear about that. So we'll talk about that. What kind of legal proceeding is it? Preparing the company, which is maybe should be first on the agenda, but we'll talk about that because if you're prepared, you do better. And then what does winning look like? Go ahead.
Great. Just
Yep.
advance. So part of understanding what problems look like and how to avoid them or how to deal with them is to understand sort of who you're facing. And that can look a lot of different ways, as we all know. Obviously, our focus is the FDA, the federal agency. But related to that is the Department of Justice, which can get involved and really increase the stakes. Frankly, in my world and in healthcare in general and companies in general, whistleblowers and relators and key TAM actions is becoming more and more significant. We'll talk a little bit about that. And then there are state agencies. And I don't know if you all have been paying attention, but when it comes to federal agencies, I think it's fair to say that we are in a time of change and a time of uncertainty. And I don't know that anybody, frankly, knows how it's going to look like 6 months, 12 months from now, but we all know it's going to look different. I think we have come off of 4 years of really quite active federal agency engagement, really almost across the spectrum, both in terms of antitrust, in consumer fraud, in sort of the financial space, and in the healthcare space, very, very active federal government, federal agencies, OIG, FDA. While the noise in Washington, at least currently, and we're, a month into a new administration, seems to be focused more on financial regulation and tech regulation, which does overlap with some of our medical devices, obviously. And I think it's probably fair to surmise that federal agencies are going to be less engaged. They may even have fewer employees. I think there's an expectation in the business community that the justice system or federal agencies, it's a math problem. And if you have this issue, you're going to get this outcome. Whereas the reality is that you're always, whether you're dealing with the Department of Justice or federal agencies or whistleblowers, you're always dealing with human beings on the other side. And if those human beings have family issues going on, it affects how they deal with your case. If their job is under threat, it is going to affect how they deal with their workload. So these kinds of issues will impact just sort of the bandwidth of these agencies. And I think it's fair to predict that in the short term, at least, and maybe even the longer term, in some spaces, there's going to be less federal agency regulation. The healthcare space, though, I don't see a whole lot of indication so far that is going to look any different in the near term. And I'm not sure that we can assume in the healthcare space, whether we're talking the FDA, CMS, OIG, that those federal agencies are going to operate differently. In some ways, one of the strongest proponents of federal agency action in the context of healthcare has been Chuck Grassley, a Republican senator from Iowa. In terms of, and if you look at the federal budget and you look at where the dollars go, you know that a lot of the dollars are going to healthcare. And one of the tools that the federal government has to deal with either trying to slow that down or claw that back is federal agency action. So I think in the healthcare space, it's going to be business as usual, or at least that's sort of I think the bet right now. I don't know what, Dave, if you have got a different view on that.
I'll come to that. And first, I want to say on the state agency part, I think you'll see consortiums of states more active in enforcement. They're suing the government now over getting their money from whatever Congress allocated for them first, but eventually they might decide that if somebody's not going to deal with some problem with some therapy or some other device or whatever it might be, they'll just do it and not wait. And they all have, not all, but well, maybe all have fraud cases or consumer protection laws, or I mean, anti-fraud statutes and consumer protection statutes and all the tools they probably need to prosecute cases that the government might otherwise. So that might increase where in the absence of federal engagement. And I forgot your question, Joe.
No, but that's all right. I mean, it was first focusing on where you think federal agency action is likely to go. But I think your point is a good one, which is even if you have a subsidence in federal agency action or engagement, states, whether you're talking California or Minnesota, are going to increase that engagement. It will look slightly different, but maybe not all that different. And frankly, you know, we have clients who are actively dealing with state agencies, and state agencies regularly have the ability to put businesses out of business, you know, sort of the business death penalty of sorts, in a state. And that's been true in the pharmaceutical area, where I had a client where they were going to lose their license to sell their pharmaceuticals. I know we've got healthcare clients now that are dealing with suspension of payments if you're reliant on state funds, Medicaid funds, or for payment. We're dealing with sort of a decision by a state agency that they just don't like how you do business, or they think that there's something wrong with it. And it's important because there's very little process. There's very little ability to engage in appeal once they've come to that conclusion. Now, lawyers right now are fighting about whether there's sort of an ability to engage in sort of a judicial review of that. But typically, and this is why it matters when you're dealing with a federal agency, whether it's FDA or the Minnesota Department of Human Services, their initial conclusion about what's going on can have devastating effects and not a lot of recourse for businesses. And so handling those agencies carefully is important, because your ability to litigate is limited. Right.
I'm going to say one other thing I don't know, or how it might change, and that is referral of cases from FDA to justice. I don't know if that, for me to sit here and say that I knew why all those got referred or not referred would be not truthful, because it's amazing what choices are made. I'm not being critical of their intellectual support or legal support. It's just, you don't know sometimes what the politics are involved or why something gets referred to justice. So we'll have to see what happens there.
And it's hard to predict, because I think there is a level of, I mean, it does ultimately go back to who are you dealing with, and frankly, knowing the person and how they operate, because typically agents, or, you know, have sort of a game plan that they follow, and knowing that game plan helps you do that. I think we should touch briefly on relators and whistleblowers, because that is becoming very prominent, both at the federal level and at the state level. Fredrikson helped a large device company deal with a relator TTAM case in California, where the theory of the case was that the company lied to the FDA to to induce it to approve the product, the device, and it was not a great case. The allegations were not great. The theories of damages were not great, and the company spent years going up and down to the Court of Appeals in the Ninth Circuit, and then doing discovery on the case, millions and millions of dollars dealing with relator qui tam cases. And the thing that has been changing over the years in qui tam cases is historically, the qui tam statute was set up during the Civil War, 1864, for basically producers that were selling sawdust to the federal government instead of gunpowder. And it was an effort to recover the funds. It has evolved, though, to it's not just recover the funds that the federal government improperly paid or paid for poor product. It is now treble damages plus penalties plus potential exclusion from a federal program. And if you're reliant in any way, or if your customers are reliant on federal dollars, Medicare, Medicaid, it is effectively putting you out of business to be found liable, making it very difficult to litigate. And what has happened over time, because the private party who has brought the lawsuit gets a cut of whatever the government gets, they're incentivized through sort of a percentage, which can range from 15 to 25%. Over the last 10, 15 years, whereas historically relators would bring a case, turn it over to the Department of Justice to investigate and to pursue, or decline, and the relator would just sort of walk away. What we're seeing more and more now is whistleblowers bringing the case, turning it over to the Department of Justice. The Department of Justice looks at the case, declines to take the case up, to pick it up and pursue it on behalf of the United States. And the relator continues to pursue the case on behalf of the United States. And so you've got a private litigant deciding that you as a company have to spend money to defend yourself, to do discovery, to produce documents, all because they claim that you're doing something wrong. And to add complexity to it, then you've got funding organizations that are now funding relators. So you have sort of financial people who are getting involved in basically buying the claim from the relator, funding the litigation, with the hope of a large recovery against a large pocketed organization. Makes it very, very challenging these days and costly. And while the Department of Justice theoretically and ostensibly is supposed to oversee those cases brought by the third parties, in practice, it rarely happens that the Department of Justice will ever intervene and dismiss a case, even if they don't believe in the case. So you're left dealing with, not only do you have to deal with the Department of Justice or the FDA in terms of what they think you're doing right or wrong. Now you have to deal with anybody who thinks that you're doing something wrong. And it used to be sort of inside employees or employees who thought that you were doing something wrong and wanted to whistleblow. Now we have cases involving competitors who have heard rumors that there's something going on that they don't think is right. Or even now in the context of the PPP loans, and that's a little far field from this morning, people that just do internet research to find out who got a PPP loan and decide whether you are eligible or not. And all sorts of entities are dealing with those cases right now. So this is an area, you're no longer just dealing with the government, you're dealing with people acting with a badge, what I like to call sort of privateers that we've sort of legally deputized to go chase money or at least claims of money. And David, I know you have been on the other side of that and probably have a slightly different perspective than I do.
Yeah, so twice, and one the government intervened and one They did not. Well, they always intervene at the end if you're successful, right? They're not going to let their share be lost, and they want to help you define what the damages are when you get close enough or you're on the precipice of a settlement. But yeah, it's those aren't going away, and they may come to other industries, including food. I'm surprised we don't get more bounty hunter cases when there's big outbreaks like the Boar's Head and things like that. I just don't, maybe you haven't caught on yet, or maybe the money's not there. Maybe they don't have government contracts is probably the answer to that.
Well, we're just seeing plaintiff firms get
Yeah.
more and more into this as they see the money that's available. And not only are you, what's interesting, if you settle the case or if you lose the case, you're not only liable treble damages, civil penalties to the government, you actually have to pay the attorney's fees for the relator. And so even if you come to a resolution at the end of the case with like negotiating with the government as to what the right number is, and it's never the right number, then you, on top of that, you have attorney's fees, which can frankly outbalance in some instances the rest of the case.
It always makes the relator mad.
Yeah.
That you got paid.
Usually
maybe more than
it's almost all.
Well, you spend 5-6 years on it, right?
Right. The relator does almost nothing in
Right.
the case. Fair enough.
So what kind of legal proceeding is it? I'm just going to start here to say that when you're doing agency appeals or challenges, you need to be aware of the Administrative Procedures Act and know what kind of rules, or are they even rules, or are they even statutes, what you're dealing with in terms of how the Administrative Procedures Act will play into the path you have to take to appeal, right? Usually you can find out by calling or something, but sometimes it's not so clear depending on what you're doing, and whether you have access to federal court or not, or you have to go through an ALJ. And sometimes there's very specific procedures depending on what kind of procedure it is, what kind of device it is, and whether it's civil monetary penalties or things like that. So the first two bullet points sort of go together in what I do mostly or have done over the last 10 years. And so you need to be aware and be ready for changes in procedures. So the new administration can, and it happens with new administrations, they just change how you appeal agency decisions. And you need to know what those are.
And sometimes they deny the rules that they've previously established and don't like anymore.
Right. And you gotta be timely. So they don't change that usually.
So typically, you start any investigation with, whether it's in the context of Department of Justice with a civil CID, civil investigative demand, a subpoena. In the FDA, they have all sorts of investigating tools. And during that period of investigation, you are subject to all sorts of requests, demands, inspection rights, interviews, depositions, substantial costs. Now, there can be some negotiation. I think that sometimes people start with the proposition, well, if they ask for it, I have to do exactly what they say. And usually there's room for negotiation based on what's reasonable. I will say, from being on the other side of the table, the problem that investigators have, whether they're the Department of Justice or anywhere else, I don't know what the inside of the company looks like. I don't know what kind of documents you have. I don't know what kind of, who does what. So it's a bit of a black box for the government in terms of how to investigate you. So what they do is ask for everything essentially, and where people like us can help is trying to explain to them what they really want to look at. And let's narrow down and try to get at the low hanging fruit and what you really need to sort of investigate whatever it is that you're investigating. And there's horse trading back and forth, but that's a delicate process because they have a significant cudgel. Ultimately, they can go to court to enforce the subpoena. depending on how egregious they're being. Judges typically are going to back them up, typically, unless it is sort of obvious that they're not being reasonable. But that is sort of the start of the process. And frankly, given the, whether you're talking the FDA, shutting down a manufacturing site, for example, or a state licensing, shutting down your license, given the potential ramifications, typically you never want to litigate. I mean, I'm a litigator and I'm going to tell most of my clients, you don't want to litigate if you don't have to. If you have viable options, it's expensive, it's uncertain, the outcomes are not great. You should avoid litigation whenever possible. Sometimes it's not possible because the government isn't giving you any great options. But dealing in this process, these proceedings and these investigations, and we're going to talk about what winning looks like in a second, but your ability to litigate, when I was a prosecutor, I had a friend who worked at a very, very large pharmaceutical company. And he was whining to me one day, or I thought it was whining, about how in False Claims Act cases, really companies don't have the ability to litigate, so that the government has a theory of facts and a theory of law. The company may have a very different view of those facts and those law and the law. And unless you're willing to litigate that in a court with a judge, it's what they say is the law. And for the most part, you don't want to litigate unless you have to. And so that's sort of the problem, is that they can look at a set of emails and selectively pick the ones that sort of support their notion of what's going on, and their theory of the law, which may not even be accurate, and impose on companies an outcome that may or may not be just. And the ability of the company to fight back is really quite limited. And now, if you take the relator example, now you're talking about somebody that, with government personnel, employees, Department of Justice, they get nothing out of this, right? They think they're doing the right thing. They try to do the right thing. They may or may not be all that successful at doing the right thing, but they're not getting compensated for whatever they're doing. With the relator actions and the whistleblower actions, they are being compensated for what they're doing. They have an incentive to stretch and shift the truth, and it creates all sorts of different impediments in how we're doing healthcare right now, at least that I'm seeing.
One more, I think it's amazing. You get into these and you think of things, right? So you need to find out, if you get a CID, for example, you need to find out if you're a target or a witness or what you are. So I've had clients get civil investigative demands, and one was the testing company for, this is public now, so I can talk about it, and it's over, for Blue Bell ice cream. So this is 8 years ago, whenever, and they had people dying from, they're still heroes in Texas. But anyway, so, it was hard to know as the testing company what your position is, right? So when you get this request for information and interviews and we're going through, you're trying to decide if you're ever going to become a target or not. I didn't, because you are doing this, you're kind of at the whim of the company and what they do with your results, right? So if you're getting presumptive positives and you're telling them, look, you got to retest these things when they come up with that result. So, constant dialogue with investigators is important, because we kind of wanted to make sure at some point we're cooperating, give them the information, right? I mean, that's not the question, but there's a difference between somebody providing information and somebody being a target.
Well, and you bring up a very good point in terms of how you participate in an investigation. I mean, you have to turn over documents, you have to do interviews, but you do not have to explain things to them. You do not have to shed light on them. Now, I've had many clients that think it's in their best interest to shed light on something, to try to help the government understand their business, why they did what they did, how it complies with what they did. But there's pros and cons to that, right? Because you can do all that, and if you don't have confidence that they're seeing things in a fair and objective way, then you are giving them sort of a roadmap as to how things work, as opposed to leaving them in the dark and letting them try to figure out what it is. So there's a risk reward in terms of shedding light on your business, which is completely voluntary, right? You don't have to do any of that under the law. You're just required to turn over documents and sit for depositions maybe and let them ask whatever questions they want and tell them nothing. But you're leaving them in the dark, and they may or may not figure things out.
Right. All right.
If you're very confident that you know what you're doing and that it's right, then it behooves you usually to tell them what happened.
You
If
can
you're
be
less confident, maybe not.
We were confident in what we were doing as testing experts, but there's so many tests done over the course of 3 or 4 or 5 years. I mean, it's the amount of information is overwhelming, and you don't know if they're going to have some expert look at that and go, well, they should have changed the testing. There was new technology beginning in this year and they didn't change that. And, if you're suddenly going to get swept up in it, even though it was clear that the company that we were doing the testing for was ignoring the results.
Well,
And luckily we had the documents to say, hey, we were waving our hands, right? But
that's a good point, because, you like to make decisions based on perfect information.
Right.
If you know that what you've done is right, all the facts, the law, it makes the decision to, provide clarity easier.
Mm-hmm.
It is a rare thing that I have perfect visibility into all facts,
Sure.
and even rarer when I have perfect visibility into all law. And so inevitably, we're advising clients, and clients are making decisions on imperfect information, even about their own company. I mean, I love it when the federal government tells me, well, why don't you just, tell me what the company did? And I'm like, well, we have 250,000 employees. That's really easy for you to say, and a much harder thing for me to do. Frankly, if I have an individual client, I don't always know what they've done. And there's a fundamental, typically, misunderstanding of the federal government by people in the federal government of how companies work and how the complexity of business and the complexity of the organization really impedes your ability to know exactly what has happened on any given business. And so part of our job is to help, a government lawyer understand, hey, if I ask the federal government for, a simple question, it will, the government would take 5 years and 50 people to tell me, an answer that isn't even an answer. I'm going to do a little better than that, but it's going to take some time, because I don't talk to one person, I talk to 20 people, because this person doesn't know the answer, but they know somebody who might know the answer, and then that person can put me. And this takes time in the context of a investigation, and managing expectations about how quickly things can be turned over, because you're dealing with the government typically with a suspicious group of people, a group of people that think, at least many of them think, that for-profit companies are bad, and that is a motive to commit fraud. I try to explain to them that in the United States of America, we've decided to have a for-profit healthcare system that only kind of helps, but they're dealing with a very different mindset than what we all deal with. And I think it's important to understand that mindset.
And they have no idea what the end is. They don't know when they're done.
No.
Right? Unless you tell them. And then you have to balance the things. Oh, we got to get going here to preparing the company, and then what's winning.
Well, Sarah and I had to deal with Congress one time, and with Congress, all you hope is that they see another, dog with a fluffy tail and go chase that, because that's the best you're going to do.
The first thing I did as a lawyer was involved the Shiley heart valve. It was a just an associate in a sea of documents before technology. And it got before Congress. I didn't go before Congress, but I got a window into that. That's a different presentation because there's no privilege, there's no confidentiality. I mean, there is, but it
Yeah.
gets wild. Anyway,
Yeah. They don't think there's privilege.
so preparing the company, I can't emphasize this enough that while it's hard, especially if it's criminal, to have people ready for investigations and CIDs and certainly inspections, but most companies are prepared to do, well, it depends on their size, but larger, sophisticated medical device and drug companies for sure. But you need some education even in the C-suite and other places by in-house lawyers or others about what preparation well, first of all, what the process looks like, and then what preparation might look like is very important and makes things a lot easier when they come knocking.
That's exactly right. I think, there's sort of two or three things that I would, documentation is always difficult because it seems kind of like a waste of time. We know what we did, so why do we need to document it? The problem is investigations are always, 3 years, 5 years later, and, the people who did whatever it is we did are gone, and maybe even their successor is gone. And so it's hard to recreate what has happened. And in well, I shouldn't say every case, but in many cases, lack of documentation hurts the company in terms of defending itself. And good documentation, whether it's your policies, whether it's your procedures, whether it's a demonstration of what you did and why you did it, is if you can explain why you did what you did and that it was reasonable in the context of what you were doing, that's a good defense typically to most issues. The other thing that I've seen in dealing with the government is, they love emails. I was a prosecutor. I loved emails. I guess text messages are now more the same. And our business people are not always focused on, they're usually very focused on sales and revenue, totally understandable. And there's nothing illegal about that. There's nothing wrong with that. It's necessary to, the for-profit model that we have in America. What we need to do is balance that in our communications, our email communications, of revenue and compliance, and making sure that the tone from our leaders and our managers and even our middle managers is balanced. There's nothing wrong with holding people accountable to their sales targets, but making sure that they understand that sales has to be coupled with compliance is, important. And, the government lawyers or the relator lawyers or the agency lawyers, when they see an email that is unbalanced and focuses solely on revenue and profit, they start to see red lights, and it makes your job defending the company more difficult because there's an imbalance in the email, and then there's an imbalance in that government attorney's mind, which may be entirely unfair, but that's how they're used. Those, there's a selective process. I've got a theory that they're cutting short on compliance, cutting short on inspections, cutting short on audits, and it's causing problems. And here's this email that supports that notion. So I think that's good. We should turn to.
I'm going to say one more thing about this. If somebody sends you an email identifying a problem, answer say, I got your email. I understand your concern, or if I don't understand it, let's get together and talk about it, and then document the resolution. I never forget going as a young associate, telling the guy who was going to try the case all the problems. He goes, well, what's our story? Well, then you got to go back, right? Because you're so focused on identifying the problems. But the companies have good stories to tell. They probably did address a whistleblower's problem. Well, maybe or maybe not. Well, but sometimes they have. And so when you document things, when issues come up, and they probably come up a lot, make sure you document the resolution.
Well, and I guess I would also discourage people from using hyperbole or
yeah, absolutely.
or conclusions, factual conclusions that may not be based in truth. I always remember the CMS official following healthcare.gov who had the email talking about how we don't want healthcare.gov to crash on takeoff. And he got called in front of, Congress to testify about his email about crashing on takeoff. That was just not a pleasant day for him. And I sometimes would show a picture of him testifying in front of Congress to show to our business leaders, imagine being in a deposition where you have to explain your emails. Got to use email, got to communicate. I understand that. But the words that you use, you may have to explain someday in a less than pleasant circumstance. But we should talk about what winning looks like, because winning doesn't look like winning. It looks like not losing a lot. That's it looks like
protecting the company, keep doing business, keep having government
losing
contracts.
as little as possible. And the justice system, the litigation system, none of it is really set up to deliver fairness, and it is costly. It is painful. It is distracting from the business. And so getting through things as quickly as possible, and moving on and getting back to the business that you're all in is the only goal. And so people can spend a lot of time getting caught up in fighting things that they think are unfair. And when the government is being unfair, which it is, that is a costly and painful principle to try to fight for, and usually ends poorly. And so if we can reset expectations and just try to keep the issues narrow, don't expand more than we have to, so keep the issues narrow and move through it as quickly as possible. I think that's the reasonable expectation and goal for companies dealing with these kinds of issues.
What are the issues that you're resolving? And who with whom, right? So if False Claims Act case, does the state have an interest? Do they know about this? Are they going to bring a claim? They're probably not going to get them to the table, but you might. What does OIG say? Even though you're settling with the relator, so they might have a say in it. So get as many parties do you think are relevant involved in the settlement as you can. And then what's the compliance going forward? Do you have a set of expectations and requirements for compliance that are different than the normal ones that you've been acting under as a result of the settlement, and for how long, and things maybe you've all been through, but an important checklist, I think.
I know we invited questions at the beginning. It's early, but we're getting, coffee is settling in. I'm wondering if there are any questions, but I know that we're about to time here. Anything? Okay. Thank you very much.
Sorry, there's one online question that I'll read off.
Yeah, please do. I'm sorry.
How will
It's too small.
potential administration changes impact the role of the FDA ombudsman in the legal process?
Boy, if they have one, I don't know. I think what's going to happen if I can only predict on what I think the principles are of this administration. So a war story. I've represented clients, especially in food, where if they have to comply with new changes that are loosely connected to the statute and the rules, right? So their interpretation, I think, is outside what the rule actually says. I think there's going to be less enforcement, especially against smaller companies, right? That might be actually a good result. So that's all I have to say about that.
Yeah, I can't speak to the FDA ombuds person other than just sort of the general uncertainty in DC. Although, you don't hear a lot about CMS and FDA at this point. At least I haven't. Right. I think what we are moving towards in a bigger picture, and this predates this administration, is less we hear a lot about Chevron and sort of the reliant, the court's deference to administrative bodies. That is going to continue to shift away from sort of reliance on administrative bodies, giving people a little bit better leg up and maybe the possibility of going to court.
Depends what jurisdiction you're in.
Right, it depends a little bit what's going on. I think that trend is going to continue, but again, that's a long and painful process. So-
I've never found that the ombudsman useful, so I guess I'm maybe the wrong person to comment on it.
Yeah,
Go ahead.
So why don't you just explain a little from why key TAM actions, how they work internally within the U.S. Attorney's Office, how it's so important that they raise the stakes won't normally see. What happens if the attorney in the civil division gets a key TAM action?
So a relator files their complaint under seal. So the defendant doesn't even know it exists and serves it on the United Department of Justice, both in DC and at the local district office. And DC and the local U.S. Attorney's Office figures out who's going to deal with it, or if they're both going to deal with it. Ostensibly, DC supervises, although that can look like almost nothing. And I think it's 90 days that they have to investigate it originally. And they're supposed to make a decision whether the Department of Justice on behalf of the United States is going to intervene and take over the case and pursue it for the United States and bring all of their litigation resources to bear, which is not insignificant. And inevitably, that 90 days gets extended, sometimes for years, sometimes for 5, 6, 7 years.
Who gets assigned investigating? Not the individual lawyer. What does the lawyer actually do when it comes in?
Yeah.
Does he call or she call up?
The
Typically,
relator lawyer.
it calls the relator lawyer for an interview, and here's what they got on the inside, and then talks to typically an OIG agent, HHS OIG, but sometimes FBI as well.
So in other words, the case moves into, it gets assigned to be actually investigated by the federal government because a lawsuit was filed.
Correct.
So there's not, the case gets to the criminal people actually oftentimes before anybody knows whether or not they're.
Well, it goes to the civil folks first. Now, Daniel, what you're talking about is how it gets referred to the criminal folks. And there is communication, and there's supposed to be communication between the civil division and the criminal division. Criminal division takes some of those cases, in which case sometimes there are subpoenas and search warrants and interviews. That does happen from time to time. And so as a company, sometimes you think you're dealing with a criminal case, but it was really started as a key TAM civil case, but has evolved into a criminal case. Oftentimes those criminal cases don't go very far, and it reverts to, the good news is you're done dealing with a criminal investigation. The bad news is you're dealing with a civil case, and I don't know if it's better to deal with the Department of Justice or a relator. Usually companies used to cheer when the Department of Justice declined to intervene, but relators have become more and more problematic in terms of how they're financed better, they're lawyered more, there's more of an investment because there's potentially a big return on the other side. And so the plaintiff lawyers, historically, plaintiff lawyer looking things have decided to get into the False Claims Act. And if you go on plaintiff lawyer websites, you see more and more of them with, False Claims Act, whistleblower complaints in there, sort of inviting plaintiffs, employees, competitors, random third parties to bring a lawsuit against any company. And the key though, it's always about government money. So if you don't have a program looking at government money or getting government money directly or indirectly, it's not going to be a key TAM case.
So when I had they were providers in both cases, doctors, and I was the investigating person. So I worked with the assistant U.S. attorney here, and he and I did all of it. I don't recall any assistance from anywhere else. Matter of fact, I kept asking them, get some Medicare people help us out here. Depending on the case, right? So if
Depends
it's
on
a
the
giant
case.
case and it originates in some particular district and it high profile, these are millions of dollars, but not like some. And so the resources can vary within wherever you're working. So
Great. Thank you.
thank
Thanks,
you.
Dan.
Yeah. Thanks.
Good morning. Good morning.
Good morning. Great to see everybody in person. And I know there's a couple hundred people on the phone, so that's awesome. My name is Amanda Johnston. I'm a partner at Gardner Law, and I practice healthcare compliance and FDA regulatory. Primarily, I lead the compliance and regulatory teams at the firm. And before coming to Gardner Law, I've been there about 6 years. I worked in-house at Medtronic and Coloplast and United Healthcare in various regulatory, legal, and compliance roles. So I have kind of that in-house and now kind of being outside counsel experience. So yeah, and I'll let my esteemed colleague here introduce himself, David.
I'm David Glazer, and I figure we should just dive in, so I'll stick with that.
All right, great. So good. That was a really great segue into kind of what we're going to talk about now. We are going to focus on kind of practical tips and best practices when it comes to improving compliance. Does this thing, let's see. There, perfect. We're going to start with just a quick refresher on compliance program basics. That should not be new to anybody really. And then we're going to talk about the DOJ's recent issuance of their False Claims Act enforcement update that came out last month. And then we'll talk about some trends and themes from that. Then we'll go into some practical tips, best practices, and we'll finish up kind of building on the last session, talking about how to prepare for an unexpected visitor from the government. And then we'll have time for questions as well. So this is kind of where I like to start, training or presentations just to ground everybody, but these are the elements of an effective compliance program. They were initially outlined in 1991 as part of the US sentencing guidelines, and then later adopted into various industries, including the OIG, which have rolled them out for medical device, pharma, and providers. So these are, the core of what a compliance program should embody. We want to have written policies and procedures outlining the compliance rules, leadership and oversight. So a compliance officer, a compliance committee, somebody that's responsible for maintaining the compliance program, making sure that there's effective training and education in place for all the staff based on their roles, keeping effective lines of communication open between the compliance officer and the compliance hotline, so that staff know where to go if they have questions or concerns. Enforcing standards and also incorporating consequences and incentives. The DOJ is pushing for working incentives and clawbacks into compensation arrangements with between companies and employees. So that's something that's been coming up more often lately. Risk assessment really should be the umbrella over all of this. But thinking about kind of risk-based approach to your compliance program, and particularly when it comes to auditing and monitoring. And then the 7th is responding to detected offenses promptly, and then actually addressing them. So initiating corrective action and addressing issues that come up. All right, so the DOJ recently issues, every year they've been keeping track since, I think, 1986 of all of the False Claims Act recoveries that they have received through settlements and judgments. So I'm a nerd. I like to look at this every year and kind of look at the trends and kind of how it's been going. So just wanted to highlight a few. It was really a record year for the DOJ. I think everything increased with the exception of the number of recoveries. So the total settlements and judgments was 2.9 billion. That was up from 2.8 billion, I believe, last year. The number of qui tam lawsuits, highest in history, 979. So that's a trend we'll talk about in a little bit here. Total cases resolved, 558. So that was the second highest. And then also the total settlements and judgments since 1986. So I think that's when they started keeping track, is $78 billion. So you can just see how much of it's a revenue stream for them. So it's interesting to think about kind of as we see shifts in the administration and agencies, like how will this, how will the enforcement priorities shift, if at all? But you can't deny that it is a giant part of their revenue. So here's just a comparison from last year to this year. Everything on the screen went up. I think, like I said, the only thing that did not increase, which stayed pretty flat, was the number of cases, which I don't know what the difference is between the total FCA settlements and judgments and the number of cases is. But so it went up from 2.68 billion to 2.9 billion. Again, the qui tam lawsuits, that's a significant increase from last year. And we've seen that trend continue in the last 5 years. Qui tam recoveries. So they're about 82% of the False Claims Act recoveries from last fiscal year were from qui tam suits, so whistleblowers. So that is a primary source of False Claims Act enforcement. And whistleblower payouts were 400 million last fiscal year. So looking at kind of their priorities based on what they've said about last year and the last couple of years, it's not really a surprise. Healthcare fraud is the largest sector. They're continuing to heavily scrutinize many areas of healthcare fraud. The opioid crisis and pharmaceutical fraud is one that we've continued to see. The DOJ continues to aggressively pursue companies and entities that they believe had a role in the opioid crisis. They're targeting drug companies, providers, pharmacies. One case from last year, which has a interesting set of facts that I wanted to bring up, was the Endo Health Solutions. So this was an opioid manufacturer who was trying to get approval from FDA for an additional claim to their product that it was tamper resistant and crush resistant. So they had submitted data to the FDA in a supplement. FDA declined to approve that. But the field went on to actually use a hammer. So they brought their pills and another pill and would smash them with hammers to show that they were tamper proof. And so that's just an interesting way that they were kind of making that claim that it was shatterproof, it was tamper resistant. And so that is really the fact pattern that drew a lot of scrutiny in that case. So I just think it's an interesting one.
You're saying don't get hammered when you're doing your sales work?
Yeah.
That's what I heard, at least.
I can just imagine some sales reps sitting with hammers at a doctor's office. I don't know. It's just funny. Yeah, don't get hammered. Medicare Advantage fraud is really increasing. So that's an area to watch. Medicare Advantage is now the largest component of Medicare, both in terms of federal dollars spent and the number of beneficiaries. And sicker beneficiaries, companies will get more money for them. So there's been a rise in kind of unsupported diagnoses. And then either it's unsupported diagnoses or they aren't getting the proper care because their diagnoses are serious, but then there aren't follow-up visits. So there's just been a lot of activity in the Medicare Advantage space lately as well, something to watch. We're continue to see kickbacks, Stark Law violations, and then pandemic relief fraud. We talked a little bit this morning about the PPP stuff. That continues to be an area of focus, and I expect it probably will continue for a couple of years. We've seen, so this last year there were 4 cybersecurity False Claims Act settlements. Actually, the first qui tam lawsuit related to cybersecurity. So this is the DOJ's civil cyber initiative. So that's a growing area to watch, and I think it's going to become a prominent area of enforcement going forward. And then military procurement fraud. So this, again, kind of harkening back to the origins of the False Claims Act. We have some defense contractor fraud actions and enforcement, and then whistleblower incentives and key TAM actions. So the DOJ clearly they want people to raise their hand. They want people to go to the government, and they've put in place quite a few incentives in addition to getting a portion of the recoveries. But yeah, like I said, 82% of the cases from last year were key TAM actions, which is crazy. So that amounts to 18 new cases filed every week. Scary to think about. So just some of the hot themes that we saw in the last couple of years. Again, opioids is still going to be high on the list just because of the visibility. I think we'll continue to see kind of provider, pharmacy, pharma company scrutiny in that area. Lack of medical necessity. So we're seeing cases where claims were submitted to Medicare that lacked medical necessity. Unnecessary services. There were a couple cases where patients were being treated for mental health conditions, but then instead of discharging them, as would be kind of typical with that particular condition and the standard of care, they did not. So they were able to continue billing when, they didn't meet the criteria to receive that inpatient care still. And then I mentioned Medicare Advantage. I think we're going to see that particularly with elder care and kind of community health areas. So just something to keep an eye on. Kickbacks, I think this is going to be it's here to stay. We are continuing to see traditional kind of kickback cases, paying doctors more than fair market value, paying them for services that weren't rendered, luxury trips, lavish meals. Almost every week, I feel like another settlement comes out, even just in 2025 so far. And we've now seen kind of a resurgence on speaker program focus. There was a recent case, Pfizer just settled for it. Well, it was Biohaven that Pfizer is settled on behalf, but the government is definitely looking at speaker programs still. So something to look at. I was at the Pharma Compliance Congress this fall, and Mary Reardon from the OIG was there, and she had reiterated that there would be more speaker program settlements coming. So she made it sound like there would be several. So I imagine this is probably the first of a few.
So, man, I'm going to chime in just real fast on that one, which is, it's interesting. If I had to pick, would I rather defend a program that has 500 physicians paid a small amount of money, or 4 physicians paid a huge amount of money? I would definitely prefer to defend the latter. And my thinking is, if your program is designed to encourage kickbacks by paying doctors, you can't make the money off of 4 doctors, right? The referrals from 4 doctors aren't going to do it. So even though those doctors are making a lot of money and it make it sound worse because their take home is bigger, I think it's much easier to defend, because if you're trying to come up with a scheme, you'd want a lot of doctors in it. And so I have a strong preference for using physicians, the same people, a lot, and keeping the pools small. So that's
That's
my
interesting. Yeah, no, that's an interesting point. Because I think in the Pfizer case, it was mostly in the lower tens of thousands, but then there were a couple that were up higher. So yeah, it's a good point. So just lessons, kind of takeaways. The theme, whistleblower risk, is really at an all-time high. Now's the time to kind of look at your internal reporting mechanisms, remind staff of, we really want you to report concerns to us before you go to the government. The idea is that you guys are detecting fraud before the whistleblower does. And I wanted to bring up, there's kind of a nuance in one of the self-disclosure programs, that there's this 120-day rule. I don't know if anyone is familiar with this, but I wanted to bring it up because I think it's just odd. So whistleblowers, if they report internally through their compliance hotline, and then report to the DOJ within 120 days, they essentially are eligible for an increased award. So they're trying to incentivize whistleblowers to first report internally and then report to the government. But then they also go so far as to say, if the company receives an internal report and then self-discloses that within 120 days, the company is then eligible for that disclosure program. So they're almost creating like a race to report. So, I mean, I guess, if you do get a report, investigate it quickly and try to figure out if it's something that would rise to the level of something that you would want to self-disclose because you have that 120-day window. I think that's an interesting nuance. But it'll be interesting to see how that plays out if it does play out. But yeah, essentially creating kind of a race to report. Healthcare enforcement is not slowing down. It's the majority of False Claims Act. So, it's not a time to sit back. Cybersecurity compliance is something that companies should be looking at, especially if they're contracting with the government or have even contracts through, say you have a software and you're licensing it to a governmental agency or working with a governmental agency, keeping that in mind. And then just continuing to expect continued aggressive enforcement against improper billing, kickbacks, unnecessary services, kind of the garden variety fraud. So how to adapt your compliance program? Really the whistleblower piece, continuing to reiterate the compliance culture tone from the top. Conducting a risk assessment, if you haven't done one in a while, is a good idea. Again, the risk assessment should drive your entire compliance program. So it should be based on the risks that are specific to your company, based on what industry you're in and what your business practices are. So making sure that you are looking at those specific areas and kind of think back to that hot topic slide. Those are the ones that I would start with, but I would also then kind of really review all of your business practices and identify risk areas, and then use that information to review your policies, review your training, making sure that you are addressing and correcting issues quickly if you find them or if you identify them. Holding leadership accountable, it's a big one. It's a challenge. It's easy to say that, but just making sure that you have, and I like the discussion in the last session about emails and writing it right. It really is so important. And I think that trickles down into the organization. It does. So just tone at the top is really important in making sure that compliance is front of mind. And then keeping an eye on enforcement trends. So, I feel like every day this last month, there's been my email box is blown up with different updates and things that are happening in the government. But just keeping tabs on that is really, really key, because then you can be nimble and make adjustments as you need to, or as priorities shift and enforcement trends change. And just in closing, kind of, again, going back to the whistleblower self-disclosure piece, is honesty the best policy? So just thinking about, and again, there's not a right or wrong answer here. It's going to be dependent on the situation. Again, think of that 120-day rule. So if you're the company, you don't know necessarily if the whistleblower is going to go to the government, but still having that timeline in mind and thinking through like, okay, is this something that we would want to disclose? And then risks and benefits of that. Some risks of disclosing. DOJ could expand into other areas. They could start asking questions and trying to keep them kind of reined in it will be a challenge. Once you disclose, you can't go back. There's no guarantee that you're going to receive a presumption of a declination to prosecute or anything really. And there's a risk of them finding additional issues that you didn't anticipate or didn't know about. But if you don't disclose and they discover it after the fact, or the whistleblower goes, and you don't know that, and within 120 days, they go and report it, you could be worse off. So penalties could be more severe. You wouldn't get that cooperation credit necessarily. So yeah, just, it's an interesting dilemma to consider, and there's pros and cons on both sides. All right, and that's all I have for, I'm going to hand it over to David.
So I'm going to talk a little bit about kind of cultural things and the like. And my goal is to leave a few concrete points. So we started a little late, so we will end at 10:35, whether we're done or not. And so, in America, there's a lot of talk right now that there are culture wars. That's also true in compliance. And so I'm going to start with it. This is a bit of a question. I'm going to make the people in the room raise your hand. Those of you who are online get to kind of ignore that part. But so do you think compliance is, and I'll go through all four and then show you, is it doing what's right? Is it doing what the government says, which apparently this isn't going to work. So let's try this. There we go.
Oh, that one.
We went. Okay. Is only your computer working?
Yeah. Which one do you want me to do?
Yep. Okay, apparently you can't back up very easily. There we go. Well, that worked really well. So is it doing what the government said, right? Which that to me is that's my quintessential, the government said. Is it doing what's legal, or is it doing something I hadn't thought of? So is it doing what's right? If put your hand up if you think it's doing what's right. Okay, couple of hands. That is, so if I give this talk at the Healthcare Compliance Association, that's what most people put their hand up at, okay? So, and part of what I'm getting at here is when you're working with compliance and legal, there's a cultural gap in how you get past that. Because at the end, I think we all have to speak the same language. Is it doing what the government says? And I see some nods here, couple, so I'm going to go that we're 7% on each of those two. And how about doing what's legal? All right, that's the majority. And I think for lawyers, that's what I would hope to see. Doing something I haven't thought of. Is there some other option I've missed? Okay, what did I miss? All of the above?
Yes.
The old all of the above answer.
Yes.
So here's what when people say it's doing what's right, I immediately say, okay, I've got money. And this, for those of you who don't bill, this isn't the best example, but for those of you who bill, I've got an overpayment that I want to refund. How far back do I go? Using the what's right test, how am I going to answer that question? And I think the answer is I can't, right? We are in a regulated environment. And so doing what's right isn't, I mean, it may sound good, but that is not. The FDA, there isn't an ethics thing here, is what the FDA says and what the FDA doesn't say. So I think I'm staunchly in the doing what's legal camp. And as for doing what the government says, I would say if that were the case, we don't need lawyers. We wouldn't have jury trials. What the government says would go, right? So, oh, thank you. You got to remember that I can't use my computer. All right. So real world problem. Someone walks in, and this sounds like the setup for a joke, but I heard that's illegal is what the person says. And your job is to figure out, or the job of your compliance person, are they right? In which case you need to take that seriously, or do you need to talk them down like they're wrong and you need to explain to them why they're wrong? And so I am a lawyer. I am very much not a psychologist, although I am married to one. This is an area where I think law and psychology merge. And a huge part of this is getting everyone on the same page again. Now, often in life, there's a Billy Joel song for things, right? So this could be, Alex is looking at you like I'm crazy, but it's a matter of trust. Oh, so you don't like Billy Joel? Fine. It's a matter of trust, angry young man, keeping the faith. I could just go on with Billy Joel songs, right? So if someone comes in, you've got to figure out if they're credible or not. And one of the big things is listening with an open mind. But one problem is I think there are often what you might refer to as frequent flyers in the compliance world. They're the people who cry wolf, and you wind up with the, wait a minute, isn't anyone here a real sheep problem? And I would posit that if you've got someone who is a frequent complainer such that you are no longer listening to them, one of two things must happen. Either you need to readjust your outlook so you are capable of hearing them, or you need to part ways with this individual. And the reason for that is what I call the stopped clock axiom, which is even a stopped clock is right twice a day. And so the person might have complained 30 times before and been wrong 30 times, but if they're right on the 31st and you don't listen to them, it isn't going to end well. And so you either have to keep listening or have them gone so they can't complain anymore. And that, I mean, firing a whistleblower has all kinds of employment issues, I know.
Yeah.
But frankly, it is better than not listening to them anymore, right? Like
Yeah,
that's
that's
if you're choosing between them, that I think is the better poison. Now, I mangle this quote all of the time. I think it's Indiana Jones in The Last Crusade. And it's, you must choose wisely, for one grail brings you, the true grail brings you life, whereas the other takes it. Something like that. There's a lot of choosing wisely that happens here. And one thing I'm going to skip ahead of for a moment, which is, how much thought do you think about how you interview people for your compliance team? I think it's one of the most important things you do, and what questions you ask will matter. So I remember once interviewing for nannies for our house, and you're thinking, what does that have to do with anything? Well, it'll show up here. Have you ever been in the big house? I asked, and the person was like, oh, well, yeah, and you start getting answers to this, right? You should be asking people at your compliance process, hey, what's a time you disagreed with your boss? What did you disagree about? How did you handle it? What happened? How did you decide if you were right or your boss was right? Because a lot of compliance are situations where someone thinks something is illegal and you want to figure out, will they listen to you if you try to talk them off the ledge? And will they bring it to you, or will they go be a whistleblower, right? Which approach are they going to use? And you can learn a lot of that if you ask, but it makes the interviewing thing really important. Then another thing you can do, it's The Power of Coffee, which has me thinking Huey Lewis, The Power of Love, different song. I had a compliance officer once who took all of her people out for coffee on a regular basis. And the benefit of that became clear when someone was really mad at the organization and they went to her because they trusted her. And so I think there's a lot to be said about being approachable. And some of that is like telling stupid dad jokes like I did, right? You want people to feel like they can come to you with the problems. Then Name That Whistleblower, which would be a great game show.
Yeah.
So I, at one point, had been through 30 cases where there was an FCA case with a whistleblower. And, like everyone, we were trying to identify the whistleblower. I had managed, or my client had managed to come up with them for the first 30, 0 times. I'm now at 2. I've identified 2 correctly since then. It is a terrible game to play for 2 reasons. First, my 0 for 30 demonstrates, I might just be bad at it, but you're not going to figure it out. But second, the process of trying to figure out who the whistleblower is sends a message to people in the organization, which is that you care, like you're trying to root it out. And ultimately, you don't want people to feel like who called the issue is what matters. It's the issue that matters. And so I really think that the game of Name That Whistleblower is counterproductive, and I don't think it's good to engage in it. So next we've got aha, which is you don't want the person to feel, which is take on me, right? That was okay. So I only lived music in the 80s. So when someone comes in, I often wonder, is it better to engage them right then and say, I think you're wrong, or is it better to take it under advisement? And I increasingly think it is better to take things under advisement because the person feels listened to. And like I did a webinar, we have our monthly webinar, and yesterday I got something wrong. The 60-day rule had changed and I missed it. And I learned that by going back afterwards and, kind of realizing I'd goofed. And that can happen. And so I'm a big fan of taking things under it. And then I also want to ask people for citations to authority. And of course, citations to authority would be abbreviated CTA, which is the Chicago Transit Authority. And that's because it is hard to say I'm sorry. All right. That was 2 80s songs on one slide. But if someone comes in and says, we think you're doing it wrong, they're in the best position to say, what rule are they relying on, right? And they may have one, they may not. They may just be in it's immoral camp, right? You're doing the wrong thing, which is different from the legal thing. Then the legal hierarchy, everything on this slide is binding. So the Constitution, statutes, regulations, national coverage decisions, those are all binding. Everything on this slide is not. And one of the things that's really big on there is LCDs. Local coverage determinations are not binding. They feel binding. And actually and you might choose to follow them. And this highlights one of the next really practical problems. You want to establish a policy that is a risk management more protective than the rule. How do you do that in a way that you don't that you're not making life easy for the government. And I think this is really hard. I am a big fan of candor. I will say things like, the rule does not require this, but as a matter of corporate policy, we expect X. Just being very direct. I don't like saying it's required and I never, compliance people sometimes will want to use exaggerations of the law because they're afraid no one will take them seriously if they just set it up as a matter of policy. And what I say, if I started swearing here right now, I wouldn't be breaking a law, and Fredrikson could totally fire me. I could say fire my ass and make the swearing thing really work, right? They could totally do that. And there are all kinds of times the company can act without a legal basis. That's fine. Don't pretend there's a legal basis, because then it lets the government come in and hoist you on your own petard. And how do I know this? I'm not going to talk about this because we don't have a lot of time, but there's a statute that says if something isn't this is only for Medicare, but if something isn't a statute or a regulation, it's not binding. And as for manuals, I lost a case once where my client had relied on something in the manuals, and the Court of Appeals said, you rely on the manuals at your own peril. How do we know LCDs aren't binding? Because there was a case out of Alabama, the AseraCare case, which happened to be a hospice, but that doesn't matter. So the hospice had a policy, or there was an LCD related to what constitutes a terminal illness. And the hospice wasn't following it. And we went up to the 11th Circuit, who said LCDs are eligibility guidelines. They're not binding, and they're not the exact criteria that are used. That case actually sat at the 11th Circuit for 2 years. And it's a big deal because it's a court decision that says that LCDs aren't binding. So I've got this cabin up north, and I spend a lot of time trying to figure out what things are. So the foot on the left is mine. I don't know the foot on the right. I'm really curious. If you're a good footprint identifier, we have a pet bobcat. It might be that. It might be a fox. I don't know. You're often trying to figure out what something is. So what do? You Google, right? Okay, Googling's a great idea. This is a regulation that won't apply to most of you guys, but there's a diagnostic test regulation. And I Googled it, and you got to have really good eyes. But look in the upper right corner. If you look in the upper right corner, you will see that this is from 10-1. Oh, this is the first hit, by the way, if you Google it. I knew the regulation site, so I just Googled the site, went to the first hit, which happens to be from 2003. So if you put that in perspective, that regulation is old enough to drive, right? Actually, it can vote. This regulation can vote. It is also not accurate. And so there are just a few other examples. It's how to look at stuff. When you Google, I'm not anti-Google. I notice it's gotten worse. I think the ability to find actual information that is right through Google is deteriorated. But you got to be careful. You have to look at the stuff at the bottom. Look at the date, right? It'll tell you, hey, when was this last updated? And I stuck here links to, if you're doing research online, these are what I use, and you want your team to use them, because if your folks are Googling outdated versions of the rules, they're not going to help. I'm going to skip what's going to get you on. I'm going to skip those two. This is going to kill me. I'll even skip that cartoon. We're going to end with, here comes trouble, right? And I have to apologize to my daughter, Zoe, every time I use this slide, because it has a shark, and the shark represents the government, which is kind of coming to get you. And as she would say, sharks are good, so I shouldn't use the shark as a, but I don't think government agents are bad. I just think it's a little scary when they come after you, just like a shark. So when you came in, you may have seen one of these, what you need to know if you're contacted by a government agent card. You're welcome to steal them. You're welcome to steal them in two senses. If you want to use one of those in your organization, by all means, just it's not proprietary. You can take the information, throw it on your stuff with your in-house contact information. So any of the agencies on here can show up. Some are obvious. I think everyone in here knows that the Office of Inspector General is the OIG, and everyone's heard of the FBI, right? You watch TV. Mafuku, the Medicaid Fraud Control Unit, which sounds like I'm swearing on stage, is out there a lot. Postal inspectors, and you may say, what does postal inspectors have to do with anything? But if it goes through the mail or wire, it's wire fraud, and they can investigate. In fact, if you have a big investigation, the odds are someone from the Defense Criminal Investigative Service or postal inspector or the like will show up. They work often in concert with the FBI or someone like that. So you might see the Defense Criminal Investigative Service on a thing and you're wondering why, right? So I'm a slow learner. You need your folks to understand that someone might show up, and you need to know ahead of time, because when they show up, agents have this habit of saying things like, I would appreciate it if you didn't tell anyone I was here. And when someone with a gun tells you they would appreciate something, most people will listen to it. And so they need to know ahead of time what their rights are. And even then, they will forget, because it's scary when someone with a gun shows up at your door. But you increase your odds if you tell them, and probably the most important thing is if someone shows up at your door, you have the absolute right to tell us. And we know that because the only government contacts someone can't talk about are terrorism investigations and a few very limited banking investigations. Those aren't the kinds of things you're likely to run into. So I think you can say safely, if someone claiming to be from the government shows up, you can tell us. And I emphasize the claiming because the number of times I've had someone claim to be from the government but not is dramatically increasing. More in the provider world than on the device side of things or in the drug side of things. But like doctors will get phone calls from someone claiming that their prescription pad was found in a car and that they are a part of an opioid investigation and it's all a scam. And that sort of stuff happens. So and they might get a call that shows up as it's from the FBI on caller ID because the number is spoofed. If you get a letter, letters are easier because you don't have a rush, right? So you figure out who sent it, you get a copy of everything you send. Letters, everyone can work through counsel. What I'm more worried about are phone calls. And if someone calls, you get their name, you get the name of the agency they're from. It's kind of like a call from a reporter. Who are you? What's your deadline? You'd ask a reporter, what are you calling about? This is the important point. Now, just a minute here. How are we supposed to know you're the real angel of death? You need to verify anyone who's on the phone. I would assume, until you know otherwise, that anyone who's calling isn't real. I would be super polite. I would say, hey, I just need to authenticate who you are. Give me your name and your agency. You can ask for their number, but that's not the number you're going to call, because if they're fake, they just, everyone who watched Seinfeld knows Vandelay Industries, right? George would say he worked for Vandelay Industries. He would give Jerry's number. That's a thing that happens. So you look them up on the internet and you call them back.
No, so just added a slide on FDA because I know we're focusing solely on FDA or primarily on FDA. If an investigator shows up, first thing you do, ask for identification. They should have a form 482. That's a notice of inspection form that they should present to you. It will outline what they're looking for, if it's routine, if it's focused. Don't panic. Notify the internal FDA response team. So again, something to have in place beforehand. Have a phone tree. Identify who's going to be kind of on call for that type of scenario. Ask questions about the scope, and then making sure that you're escorting the investigator everywhere. You're not letting them wander around. Find a private meeting area. A lot of companies like to do the front room, back room, which I think is a great idea. And then I'll borrow Tim Phillips. He's at Gardner Law. He's a former 35 years at FDA compliance officer. T-last, tell the truth, listen to the question, answer the question, stop talking, tell the truth. So that's the FDA kind of quick rundown on if FDA shows up.
And the FDA is very different because there you've got a kind of a duty to cooperate that if it's an OIG or FBI agent, I'm going to get rid of the T-last and go with just sit there quietly,
Yes,
right?
stop.
So totally different analysis because of the regulatory difference, right? So this was a real world subpoena that one of our surgeon clients got. I'm hoping that this wouldn't happen again because the U.S. Attorney's Office that sent this out kind of got in trouble. But the subpoena said, we request you don't disclose the existence of this subpoena. Any such disclosure would impede the investigation. And this is kind of what I was getting at before on they tell people not to talk. If someone reads that, will they tell you that they got the thing? And the only shot you have is if you've inoculated them ahead of time very directly with, even if the government tells you that you can't talk to me, you still can. That actually, to me, should be a part of your compliance training. Okay, very quickly, because I want to leave a few, like 5 minutes for questions. If someone has a warrant, they get to come in, right? And the FDA gets to come in. If they don't have a warrant, they don't get to come in right away. And it's rare. It is very rare for people to show up with a warrant. Much more common for them to show up with, maybe they're dropping off a subpoena. Medicare entitles the government to immediate access to records. And so you might think, I need to let them in. Immediate access is 24 hours. So there is no situation absent a search warrant where they, or the FDA, where they come in right this second, get their ID, and then they will often do the, they will take the beware of dog sign and say, this isn't a big deal. No one ever shows up at your office if it's not a big deal. They've got better fish to fry. People who, often they feel confident or they're scared, and either one can get people talking. And they can say things like, oh, my lawyer said this was okay. That statement is a waiver of attorney-client privilege, right? So it is really the goal, my goal, to get people to not talk. Then the agent often does, and people are worried, well, if we don't cooperate, aren't we going to get in more trouble? And I think this cartoon captures it so well. So the agent is the shark. I'm picking on sharks again. Okay, I'll go back and tell my people you're staying in the boat, but I warn you, they're not going to like it. Well, they're not. You can have happy sharks and talk, i.e. jump in the water, or have mad sharks and stay in the boat. The choice is yours. The agents can't make anyone attend an interview. They can't get documents without a warrant or a subpoena. They can't get privileged information. And as we've said, they can't keep people from talking. A company can't prevent its employees from talking to the government. So we can't say, I can't as a lawyer say, don't talk to the government. I can say, hey, you have the right to talk to the government. You have the right not to. I think it's wise not to, but the choice is yours. I think the point Amanda was making about tell the truth being in there twice is really important, because Section 1001, which is lying to a government agent, there are way more lying to a government agent convictions than there are kickback violation convictions. And then don't destroy or hide documents. The good news is most agents are smarter than this. Which monster did this? Godzilla, Gargantua, who? If only there were a clue. All right, we got some questions. Let's see, I see a few here. All right, those are not questions for us. Did you see any on this?
I don't.
All right, if you got in the room, so we've got 1.5 minutes or something before we give you, we go to a break afterwards, and so you can always buttonhole us. Yeah. But questions either online or here? No, they're.
Difference between responses to the FDA when it's an investigation versus an inspection. So an investigation, they're coming because they have information about something. An inspection is, well, you're on the list, and I'm coming in. Amanda, I'm going to repeat it just for the people online, and then you're going to answer it because you're the FDA person. So the difference between an inspection and what was the other? Investigation. An investigation.
So there's not really. So those words are used interchangeably, and I know Tim would correct me because I think it's investigator is the name of the person that shows up, and it is an inspection. So, I mean, yes, there's probably a difference if they're coming in looking for something fraudulent, and then they'd probably have the OIG with them. But if an FDA investigator shows up to conduct an inspection, that's like either the routine one, or they're looking for something like, you know, after approval, or if there's an issue that has been cited. So those phrases are used interchangeably, but it's an inspection typically. I guess if it's what? Yes, yes. So that's the notice of inspection, the 482.
Right now, I've always treated them different. So,
I mean, I guess if they show up with
what I tell
guns.
people to say to the FDA, if it's an inspection with 482, then the inspection rules apply and they have a right to inspect. But if it's an investigation of some specific thing, they don't get to wander around. It's that thing, and you have to find out what they're investigating.
Yeah. I mean, I suppose if they show up with the FBI or the OIG. Yeah, exactly.
All right, I see there's a question for the online folks where people here, are you going to get the slides afterwards? And the answer is yes. So, all right, I think there's a break. We'll be back here at 1:45, or I won't, but others will.
All right, thanks, guys.
You to our
Good multitasker.
wonderful audience and also to our panelists here today. Sarah, Alex, Ann, and Steve, I would invite you to each introduce yourselves briefly for the audience.
Wonderful. Hi, everyone. My name is Sarah Karlgaard. I am the General Counsel and Corporate Secretary of Fujifilm Holdings Americas Corporation. We are headquartered in Valhalla, New York. We have responsibility for 26 independently run subsidiaries, a large portion of which are in healthcare, both in medical device, CDMO, and life sciences.
Good morning. So I'm Steve Fraley, General Counsel at Coloplast for the North America office. Coloplast is a Danish medical device company that's been around for many years. We don't have that many business units, but we have 4 or 5. Yes, exactly. I've been here 5 years. Before that at Olympus and Medtronic, and before that a commercial litigator.
Hi, everybody. Welcome. I'm Ann Miller. I'm in-house at Medtronic, based here in Minneapolis. I've been with the company for 18 years and I've done FDA regulatory practice for all of it. And lately kind of focusing on more quality systems, post-market issues. Started my career at the Chief Counsel's Office at FDA.
Excuse me, Alex Rosenstein. For the last couple of weeks, I am the General Counsel and Chief Compliance Officer of NMDP, formerly known as Be the Match, National Marrow Donor Program in Minneapolis. I am a 2-time Fredrikson alum, and I was also the General Counsel at Cardiovascular Systems, CSI, and I was Compliance Officer for part of the time I was there.
Great. Thank you all. I'm really excited. We got a wonderful panel here with a lot of experience. So I'm going to run through some questions. We had a lot of questions that we came up with, and we narrowed it down to 7. And we'll see how we do getting through those in the next 40 minutes or so. We may have some time for some audience questions as well. So I'm going to start with one question about collaboration. And feel free to share your thoughts. I think I'll start with you on this, Sarah. How does your legal department collaborate with other departments, such as regulatory affairs, quality affairs, and operations to ensure compliance? And in some companies, compliance and legal are also separated. So how do you get these people talking so that you can avoid trouble?
Yeah, in our organization, legal and compliance are separated. The Chief Compliance Officer is a peer of mine, both reporting to the CEO. We find that structure to be incredibly effective. We are very, very close. We are together, really strong partners. Where it gets a little bit trickier, as I mentioned, we have 26 independently run subsidiaries, is on the quality and regulatory side.
Yeah.
And we run a lot of variety in terms of industry segments. We are in addition to the healthcare segments that I mentioned, we're also in electronic materials, as well as what you know Fujifilm to be, which is the cameras, the imaging, the printing. Quality and regulatory expectations vary widely among those industry segments, right? And our company, coming up on 91 years of existence, started in the much less regulated space. So, talking with our executive leaders around quality and regulatory, we have really evolved from when, if the camera doesn't work, you don't get your pictures, to if the medical device doesn't work, the diagnosis isn't made. And so we're spending a lot of time sort of educating just across the organization what that looks like to be a medical device company, to be a life sciences company, particularly in the US.
Thank you. I also wanted to mention that the views of the speakers are their own. And so
Sure is.
They're speaking freely up here, not representing anyone but themselves. So I don't know, Steve and Alex, if you have anything to add to that, please do.
I mean, I can, I guess, chime in on the quality regulatory piece at Medtronic, at least, and it's where I sit. So we are actually very closely tied to our quality and regulatory, especially our quality organization, our quality professionals. I think that has come, over the course of several years of just building those relationships. So they come to us on their own a lot for questions, legal questions, regulatory questions, also just what do you think of this question that are really not legal in nature, but just more kind of gut checks. I think that at least part of the work that I do is kind of bringing the core legal skills, which are critical thinking and writing, and also just investing the time with the clients over the years, sitting at the table, reading their technical documents, asking questions, and just learning their terminology so that when something does come up where they really need you, you can, kind of speak their language. But it doesn't happen overnight. It's relationship building and I guess trust building, and just learning to be collaborative partners with them.
Thank you. Yeah.
Yeah,
Alex.
I'll weigh in. I guess a blanket statement for everything I'm going to say. I'm going to be bringing a smaller company perspective, certainly much smaller than Medtronic. And also I'm finding a lot of what I'm going to talk about may actually echo some of the comments of the other panels. A lot of good advice that's actually the way I see things. So at a smaller company, it's actually pretty easy to collaborate with the other departments because you kind of know everybody. So I did easy things like I had standing meetings with, and do now also, standing meetings with the leaders in those parts of the organization. I viewed my role as kind of having eyes on everything in the organization and being able to connect dots. So having just standing meetings, even if we didn't have particular topics, helped us stay connected just on a weekly, very regular basis to be able to identify issues that were emerging. So that was just a great practical way to deal with it. The other thing I think it was David may have mentioned on the last panel is building trust and credibility and just having an open door policy so that people in other departments will come to you with issues and want to collaborate with you because they know you will address whatever the issues are. So I find that is extremely helpful.
Great.
I'll just add a little bit on collaboration is so critical in-house and navigating and staying connected. As I've talked with some of my colleagues here, sometimes it's just, can we find out what's going on and how do we do that? Because once we do, it'll change the next day. So how do you manage that? And part of that is through the relationship building. We actually, when we structured our job duties, we have people whose part of their job is to develop what I call business intimacy with the business unit. You need to know their strategies, their plans, and be the one to feed it back, even if you're not going to be the one supporting on a particular initiative or project, because it's too much unless you're an extremely small company, to try and manage yourself. In the quality organization, something we can bring, even though we're not deep regulatory lawyers, is that we can bring this idea of approaching things from a logical perspective, being a thought partner. So we, for example, will work with post-market surveillance. What's your template for the complaint response? When are you going to escalate something to legal because you heard lawyers are involved or something, or whether it was a serious injury? We look at the HHE, or whether it's a situation analysis. There's been so many times people in quality have written something that was not what they meant, and it could be taken a very different way. So part of it is advising on that kind of thing. One area of training that we've done in a couple of the companies I've been at is literally called Right Smart Training. Quality, in addition to sales and regulatory and marketing, are the teams we typically focus on that. There's a big disclaimer slide at the front, which is, this is not intended to tell you how to not write about bad conduct or how to write around bad conduct. It's basically to say we still have to do the right thing, but we just got to make sure we're accurate in saying what we mean, to try and avoid these bad emails that we hear that can come back to haunt. We actually will have some real and some mock emails that we weave into those examples. And I think that's another way to help do some preventative lawyering. In terms of with the quality organization, I think the other key part we get involved with is a lot of the communications, especially if there is a field action. Besides being kind of that classic regulatory lawyer, It's how should we structure the letter to the customer? How should we draft the internal FAQ for the sales force? Because they'll be talking about it and being asked about it. So I think we can play that role in addition to being kind of a very deep expert.
Yeah, great feedback. And I think it's really important, as you've all outlined, to stay connected with these different departments, especially as quality issues have become popular theories for prosecution, especially with whistleblowers in the government, as off-label cases were lost. A big one because of this law firm right here with Howard Root's case and Vascular Solutions. And the government was not as excited, has not been as excited to bring those cases for off-label promotion, but so we're seeing a ramp up in some of these quality cases. So it's like the panel pointed out, really staying in touch with those quality folks and making sure you're available to them is important. Moving to the next question, and I'm not a panelist, but I had to add my 2 cents in there because I really enjoyed your comments. So number 2, and I'm going to pitch this one over to you, Steve. How do you handle situations where there's ambiguity in the regulations or guidance? And as we know, there's a lot of ambiguity out there. And I have a second part to this, and you can either just answer that question about the ambiguity, if you'd like to tie in how you determine how to move forward, that would be helpful.
Part of the hardest part of the job, right? When there's no clear answers or there's more ambiguity. And I approach it with what I call the big mental algorithm that I throw all the factors in, weigh them each differently on a case-by-case basis. How strong or credible are the 2 arguments? What is the risk? What is the type of risk? Is it a pure compliance risk? What are the business repercussions if I go down one avenue? If I take one avenue, am I putting something else at risk beyond the immediate issue? I try and put all that together. And I can't say there's some magic formula, but at the end of the day, you weigh all that out and then come up with a plan. I will tell you, these are the situations where I do consult deep industry expert outside counsel to say, here's what I'm looking at. On the one hand, I see this, on the other hand, I see that, and ask for their opinion. We all know you can go to lawyers who will say, well, this could happen or that could happen. No, I need to have somebody who can say, I ran into some similar situations with other clients, maybe not the exact issue, but some very similar analysis. Here's what they did. Here's what we saw was a problem with it, or here's why it turned out well. And what is the probable outcome, not what might happen. And I think if you find people like that, these kinds of situations are where you want that insight to see if they see something you're not seeing. And then, the hardest part of the job is use your judgment and come up with a recommendation.
Thank you.
There's a couple of things I might add to that. One, very practically, I tend to be a little bit intentional about making sure that I at least have a level of consensus within my legal team, right? Either consulting the experts or beyond. But then I will often bring some trusted, smart business colleagues into the conversation, right? I don't think it serves you in the long run to pretend like you have the answers. I'm not suggesting you do this, but to pretend that you have the answers when the area is in fact gray. And I understand, leaders are different sort of in their preferences or expectations, but I found it to be most successful where you are working with smart partners on the business side where whether it's in quality or regulatory or whomever, your business clients, and you lay it out there and you have as much of that context and information. And I would also add, there are many firms that have former regulators, and this is an area where we will partner with our government affairs team as well, especially as the administrations are changing, to sort of get a sense for, okay, this is the landscape, this is what we understand the regulations are today. How do we think the current regulators are going to judge that? So we've been able to develop some relationships with folks who know the current regulators and at least can, as best as anyone can, try to crystal ball that and bring that into the conversation as well.
Yeah, and I think that's especially true for the FDA space because so much of what is required is not in the regulations. And I'm saying required, I would put my little air quotes up. much of what FDA does, for instance, in especially in inspections, right? So the factory inspections, the on-site inspections, what they'll look at, what they'll ask for, what they'll expect from you, you can't find in a regulation, and you probably can't even find it in guidance. You might find it in other warning letters in the industry. If you can, if you have the benefit of, I mean, I'm in a big company, so I have worked on several 43 responses. And so I sort of have that library in my head. But if you can, FOIA them or just understand what when FDA, has a design control requirement, what does that actually mean? So it does take some work. We have in-house counsel that, we're FDA experts, but if you don't have that, then going outside, the FDA bar is very, very, very steeped in this area because it can catch you. If you look at the regs and you say, I don't need to do this because it's not in the regs, you might get caught. And if there's something, I think sort of with the change at administration, and as we watch that, that's going to be kind of a question for me is FDA is clear that guidance is not required. We tend to follow it because we think it sort of gives us a guidance on what FDA expects. It's a good compliant place to be. It's the safe place to be. But what will be enforced, if you will, a year from now? What will all of those guidances that are maybe newer, will they be viewed the same way? So that'll be something that we watch. And I guess just for me, if it is ambiguous or if it is kind of a judgment call, I do the same. I bring in a business partner or a quality partner, because the last thing you want to do is recommend something that they can't implement. That's completely impractical. Our system can't do that. We work in IT systems. Our complaint handling system doesn't have that function. We'd have to do this update. You have to think about the practical implications and then sometimes work backwards from there.
Great comments. I'll add a little tidbit again. I once defended a client on a warning letter, and the FDA acknowledged they followed the guidance, but they said, we essentially expect more from you. And we were like, okay, that's tough. You're following the rules and still getting a warning letter somehow. So you just never know what the regulator is thinking. Number 3, another question here, toss. I'll send this over to you, Anne. What is the biggest compliance mistake you've seen, and what lessons did you learn from it?
I think I'm sure I've made steps over my years, but one thing that I was thinking about and kind of preparing for this is so occasionally FDA will come out with kind of a big new thing, a new guidance that seems to shift. Recently, they came out with what they call an early alert pilot program, where they're providing really quick notice of recalls that they think will be class 1, but they aren't classified yet. They come out within like 5 days. No basis in the statute, regulations, guidance, anything. It's just a pilot. And it felt really abrupt. However, if you look back over the past couple of years, you can sort of see them moving in this direction. And I think that's one thing that I'm continue to remind myself is FDA sort of gives you little signals along the way of where it wants to go. So pay attention. There's so much on the website that you have to be careful. I mean, it's kind of the Google thing, right? You can't always trust what's on the FDA website, but there is a lot of information out there. And oftentimes you can signal you can figure out what their next step is going to be, so it doesn't feel so abrupt. I don't know if that's really a compliance mistake per se, but it does help you not get caught flat-footed.
Excuse me. Mine would be that if you've got an employee who's a problem from a compliance perspective, it is not going to get better. You need to deal with it quickly, because it will fester and it will get worse and it will spread. As uncomfortable as it is to deal with an employee issue, you have to deal with it. So I think David had mentioned something about that in the last panel, but yeah, I've had experiences with that where I've regretted not taking action sooner.
Thank you. Anyone else like to share any?
Well, I'll just echo that one compliance mistake that I see happen a lot is just sort of freaking out. And I think that goes to the communications as well, just the panic sort of. I genuinely do believe that people are trying to do the right thing, and where things go awry is mostly out of ignorance or lack of understanding. However, when they do think that something has gone awry and then they panic and they put everything in email and they panic to, 18 of their closest colleagues, that's not great. That's not super helpful to the situation.
Yeah. No. Yeah. And to that end, I know several of you have mentioned writing right training. Amanda mentioned that as well. For the attorneys out there that are responsible for compliance, whether it's healthcare compliance, interactions with providers, it's privacy, it's regulatory compliance, having that training, which takes, I call it this don't write stupid emails training. It's a 15-minute training. It can be. And one of the slides we have is like the Chicken Little rule, which is what Sarah just commented on. And it's, don't panic. Don't send an email to the entire company. Pick up the phone, and the sky it's not falling. So I'm sure many of you do that, but I found that to be really successful.
Mark, can I interject on that
Please
point? It's important to do that kind of training. What scares me a little bit right now is the use of AI. People are recording meetings. They're using AI to create transcripts of meetings or summaries of meetings. So email training may be good for emails. People may not be thinking about, I better watch what I say in a meeting that's being recorded, because that creates a whole other set of evidence and record.
Absolutely.
That could be really problematic. Even if what people are saying is not what the company ultimately does, it may look like there's a culture of wanting to do things that the company shouldn't be doing. So
totally. And yeah, to your point, it's all documentation methods. So better title for it is good documentation practices, or you'll see it as GDX, because it includes text. Snapchat, they're saying whatever method you're using, well, the message disappears. Nothing disappears. It's somewhere on a server somewhere. And, there's ways the government can get their fingers on those things. So, yeah.
Those transcripts are terrible. I mean, they're inaccurate. I mean, so we use them a lot. So Fujifilm's headquartered in Tokyo. We use them a lot to attempt to do translations in real-time conversations. I mean, it's a joke. None of it are the right words.
So I'm going to toss this next one over to, I think, Alex, you are up. What are the biggest hurdles you face in maintaining culture of compliance within your organization? So this really hits that culture, which we also heard this morning in the presentations. And how do you overcome them? If you want to pull in any metrics you may use that you find valuable, feel free to do that. I also say this, like this was I kind of snuck this one in, but I'm sure we've all gone through a situation too where you're buying a company and then their culture is different than yours. And that presents a whole nother set of challenges. But Alex, if you can comment on compliance culture, yeah, please.
Yeah, I mean, it's a bit of a cliche and a repeat, but obviously tone at the top is what is true. As the general counsel, compliance officer, you can't be the only one talking about it at the company. If you're the only one, it is not going to resonate and become part of the culture. So it's also not only the CEO mentioning it at all company meetings. It has to be among an entire executive team, and it has to flow down to everybody. You have to talk about it not just in compliance training, but you have to talk about a culture of ethics and compliance sort of throughout the course of the company's operations, and be very visible about it. I reminded of a story that this was not any place I worked, but it was a story of somebody had told me at a place they worked where there was a device company where there was a marketing, I don't know what their position is, manager, VP, something, director, who the company got an FDA warning letter, and he held it up to his team saying, I welcome this. This shows we're doing what we need to do in marketing. We're being aggressive. It's like, if you've got that, you're going to have a huge uphill battle to deal with if you're in charge of legal or compliance at the company. So hope you don't have that kind of situation. But I think you really have to create really good relationships with your peers. And so that they are cascading the messaging throughout their organizations and making sure that people understand that there's no tolerance for behavior that's outside of the norms that we've established. I don't have any metrics, so somebody else at a bigger company may be able to weigh in on that. But I think it really is just being very, very consistent with the messaging throughout the organization and not just coming from one department.
I'll suggest one metric for culture is we look at how many reports come into the compliance hotline. But I think what's also interesting is to look at how many reports come in because people went to their upline manager versus the hotline. And what we like to see is more and more coming in from managers and fewer from the hotline. And I think that can give a signal as to your compliance culture. When I think about it from a quality management system, I'm sure we all get, there's the quarterly management, voluminous slide deck. And when you go through that, I think one thing I always do, is there anything in there I saw that should be in a CAPA that's not? And then I also ask myself, did the deadlines on the CAPA just keep getting pushed back? And is that just ongoing? And that, I think, then forms some discussions from kind of a quality compliance perspective.
Thank you. I will move to the next question and pull it back to you here, Sarah, if you don't mind. So number 5, what are some of the best practices for training employees on compliance matters? And how do you ensure the training is effective and retained?
Yeah. I mean, I think this is really hard, but honestly, my short answer is just as many methods as possible, right? Obviously, you will check all of the boxes. There will be written training. There will be anything through your learning management system. You will meet all of those expectations. But to the extent that you can actually have face-to-face conversations, live trainings, and to get into the business when it actually is applicable, I find to be incredibly helpful for, creating that culture of compliance. So when there's going to be trade shows, when there's going to be sales meetings, be in that and tailor the messaging to what matters. Likewise, if you're going to have a big product launch, or if something goes wrong, don't ever let a crisis go to waste. If something goes wrong, do not go too far after the case is resolved before you come back and you do a retrospective and you say, how could we have done that better? How could we have done that differently? What does can we marry it to our compliance efforts to say, oh, this is where we sort of fell short, or this is where we fell awry. One sort of concrete example that just came to mind. So I have 2 lawyers who sit in our Brazilian office, which, if you didn't know this, I didn't until I joined Fujifilm. Brazil has a more aggressive litigation and regulatory structure than even the US. I always thought the US was the worst. Turns out I was wrong. And they hold an annual all-day compliance event known as Fair Play. And they theme it in the entire organization. I think they have 180 employees down there. Takes the day, and it's driven by games. It has a different theme every year, the Olympics, but there's trivia, there's physical games that are all rooted in compliance. And I think if you can get in an organization that is willing to support an effort like that, I mean, they love it. It is a joyous day. I think every type of methodology is where this really comes in.
And I'll just add to that, there's obviously the formal training we do. Lawyers do it often in-house. Don't be afraid of the informal training and seize those opportunities. Sending out notifications or notices to your clients about a recent warning letter, key takeaways. I do that often. Hold office hours so they can come to you with questions on, recall determinations. Constantly building that, regular cadence of you can come to us and ask the specific questions. It may not be training per se, but every time you're talking about those issues, you're training on it. Sitting in on the quality leadership team meetings and presenting there, just finding these pockets of places where you can interact with your clients, and just, even if it's just one thing, it tends to, in my experience, generate some really rich discussion. And I feel like the takeaways are more concrete and real in real time than often the kind of the formal presentations.
Yeah, and I agree. We have to do all of the required annual trainings and things like that. One thing I've noticed, I'm certainly no expert in adult learning, but lawyers, compliance people, quality people like to have kind of kitchen sink trainings with, now the one-day thing the all-day thing with the trivia sounds good, but doing, having a 2-hour module that every employee has to complete that covers the whole range of topics, I don't think that's that effective. I think it's more effective to do smaller, targeted trainings on particular topics. Kind of ties into what you were saying, but and you can find online modules that work pretty well for that purpose, where you're just talking about, once a quarter, a couple times a quarter, you have a 15-minute module to look at instead of trying to take in everything that falls under, a compliance program. I think that works. Personally, it works way better for me. I think the cybersecurity people do this really well. Instead of doing it all in one big chunk, it's just very consistent. Every quarter, you're going to have a couple of these. And I think it works. It just resonates and works much better.
Yeah.
We've also had some good success with publicizing near misses, whether they're ours or just in the industry, right? And I find that people pay attention to a short email that is directed to them than something buried or blasted or, and so we've had some success in sort of just in an ad hoc way saying a phishing attack was leveled against our CFO. He followed our steps and we were not, victim to that. And I find that, you use people's names, you talk, specifically about the situation and it's like, oh, well, that's interesting. It's interesting to know that the CFO almost got spoofed.
Yeah. Makes it more real, right?
I'll just build on some of these themes. I think, Alex, you make a really good point about timeliness. This last year, we just finished our annual code of conduct training was 75 minutes, and it's now been boiled down to somewhere between 15 and 20, depending upon how fast you read. But the other thing is if you're in one of these large companies where you have all this electronic training, is really work with your HR and functional leaders, because some people are getting way more training than they really need. Are people getting the kinds of trainings on the topics they need? Now, you want to err on the side of overtraining, but you don't want assignments that just don't make a lot of sense. Another tactic that I think is real helpful for the live training is when we're in front of the sales team, we actually have the sales leadership participating in the little skits, the little role play exercises up in front of their teams, actively talking about why this is important. It sometimes takes a little cajoling to make that happen, but it pays off in the end. So I think that active, it's my leader, I better listen, right? So that obviously can be very effective.
Some great comments. And I know Amanda and I combined have probably performed, I don't know, hundreds, if not close to 1,000 trainings. So for what it's worth, I'll jump in here once again. I think the online training can be really successful and necessary to examine people and then to teach them and then see if they pass the quiz, right? Because they actually start to take it a little more seriously. I think in-person training, though, if you can get in at your NSM, your national sales meeting, and get up there, even if it's for 15 minutes and just be like, here's what's hot. We're seeing speaker programs that's an issue right now with the government. So we need to be really tight on that. And then have a forum in that same NSM where they can ask questions. I know, if you're familiar with Car Talk and they had Stump the Chump where they would just let people call in, I'd be like, ask me any question you want. And, that can be fun for them because they can actually, get a beef out like, hey, do I have to do this with sunshine reporting? Or, they might have a question there and the whole audience can hear it. I think, Steve, your point to making stuff entertaining, if you could somehow pull that off, that can really be exciting. And exciting as compliance can be, right? But if you kind of pull in current events, I know both Kardashians have been the targets of warning letters from the FDA, and they're not all that old. So if you could kind of pull some of that in, people are like, oh, Kim and Khloe got warning letters? Why? And just find forums to engage them. And if you do, like you said, don't let a crisis go to waste. If you see some sort of abuse, like with expense reports or something going on, it's a great time to remind the field, you need to follow these rules and, use that to your advantage. You probably, if it's a issue that's minor, you probably don't have to fire someone, but it's a good way to remind the field and obviously like no death by PowerPoint, people just kind of tune out, right? So we've got a couple questions left in about 9 minutes. So I'll just toss this up for anyone on the panel. I was up here looking, if you're wondering, I wasn't on Snapchat. I was actually confirming that I heard some news from Charlie from our office that RFK Jr. is confirmed. So we now have a new HHS secretary. And I expect the FDA commissioner to be on the heels. So of
So
that.
everything's perfectly clear now.
Well, we'll see. We'll see where that goes, but or completely unclear. We'll see. But I have this next question. Looking ahead to 2025, we're in 2025 now. What emerging compliance challenges do you anticipate, particularly in areas like data privacy, cybersecurity, AI, in healthcare? I would say even just to broaden that question out, now that we have a new secretary and we're seeing all this disruption in the rest of the government, I wonder if HHS will see similar disruption, or FDA. If anyone wants to take that one, please.
Well, the challenge is kind of what we joked about, is no idea what's going to happen, what the enforcement situation is going to be, how many people will be working there. I mean, there are so many issues right now that create unpredictability that it's really difficult to navigate and deal with. So I think, Sarah, you said, like, you got to stay calm and not freak out about what's going on. I would say if you're a government contractor or get government money from grants, there's going to be attention paid to you if there are enough people on staff in the appropriate agencies to actually look at you. So I'm terrible about predicting the future. My only prediction is that there's no way to know what's going to happen here, and you'd have to just be really flexible and adjust.
And I've asked myself this too, if there's right now, I don't know. But, as time goes on, as the dust settles and we kind of figure out what the environment is, at least, where my world is an FDA enforcement, not the, like what we were talking about earlier, but inspections and just sort of the run of the mill, the bread and butter enforcement. And that's a big question to me. Will they be inspecting? Will they be, expecting recalls like they have been? Where is that going to be? And I'm asking myself, how do I advise my client? Do I advise my client knowing this is where we've been? And even if maybe the compliance environment is different, does that change the advice? I mean, it can be a conundrum for in-house counsel. I guess where I'm landing right now is no change. We are where we are, not just because FDA thinks we need to do it that way, because we think it's, good for the patient, the appropriate thing to do. And we're a global company. So we have NVISA, we have TGA, we have BfArM, we have HPRA, and I can go on and on and on with the alphabet soup, but the global regulators right now are very active. So, if the regulation is sort of keeping you, where you need to be, that's where I'm also looking as well, even if FDA is just really unclear right now.
Yeah. Anyone else want to jump on that? Or are you good?
Well, I mean, I think it goes in both directions, right? The uncertainty goes in both directions. It might be that there might be additional scrutiny. It's far more likely that there's less. But then what do you do with that, right? I mean, we have a ton of environmental compliance issues throughout our organization too. And we're sort of going, okay, well, if they roll it back, that might be good for us. But is that good for us? And, or do we want to make any changes in reaction to that? I think, sort of weathering that turbulence is something that I'm talking with my team at great length about. It reminds me, it harkens back to, I was a HIPAA lawyer early on in my career, early when HIPAA existed. And you talk to the folks who colleagues that I worked with when HIPAA had no real teeth and no real enforcement. And at that time, they still protected the heck out of the data, right? It's very interesting to sort of kind of gauge how much the regulations should or do drive these things, or if it is in fact just the right thing to do and consistent with values, but also good business practice and, going to drive to that bottom line as well. So it's going to be interesting.
Yeah. Yeah, I was interviewed around the holiday by Tom Curran at All Things Considered on that question. How will this new administration impact the FDA? I'm sticking with my bet, which is I don't think it'll be largely impacted. At least like mass firings, the question was, will it be gutted? I don't think it will be gutted. I think it's very difficult to gut any group of the government, but now we're seeing different departments or at least agencies being closed. But the FDA, I think we'd all agree, I represent a lot of manufacturers, also providers. You need a strong regulator in this space. So I think the industry demands it. And so we'll see what happens. I think we should expect some changes. Moving to the last question, I think we're at just about at time. So maybe just a quick answer on this one. What advice would you give, if you have limited resources, what advice would you give smaller companies that are working on a pretty tight budget with how are they build out a compliance program?
I can take that one. I think we're a little smaller than, or my past experience. So it's hard for lawyers and compliance people to do this, but you have to be comfortable not dealing with every single little thing that comes up. You really have to assess what are our highest risk areas, what are the most likely to occur, and really focus most of your attention on those. And there's going to be you have to get comfortable saying good enough on the other stuff, because you don't, particularly if you're a team of one, which I've been in the past, or a team of two, you don't have the bandwidth to deal with it. And you're also in an organization, most likely, that doesn't have bandwidth in the other parts of the organization that you might need to tap into. So, if you're doing an investigation and you need help from IT in terms of doing searches and things like that, there's nobody whose job it is to deal with that. So you've got to find and have good relationships with the people in the company who you need to leverage to do the kinds of things you need to do. So it's difficult and it's uncomfortable. The other thing I would say is often you draw on outside counsel because you don't have the internal resources, but outside counsel doesn't always know how your company operates. So you have to help them along a little bit in terms of understanding the constraints you're working under, because the default of an outside lawyer is often, here's the gold-plated perfect way to do this. And you may say, I don't know, I can't do that. I don't have the time to do that or the resources to do that. So you have to help them understand what is scoped appropriately for your company and your company's, your resources. And at the same time, trying to do things quickly to not make them become bigger problems. So it's tough. It's really tough. But I think doing kind of a risk assessment at the start helps you visualize where really the areas are you need to focus on.
Great. Well, thank you. I think we're at 11:29 Central Time, so I think we'll end it there. Thank you very much to our panel. Appreciate you guys.
Thank you.
I'll say a couple parting comments. The session today was recorded, and you will receive an email with a link to that recording. So if there's anything you missed or you want to go back to, you can do that. In the email, there's also a survey. We'd love to hear your feedback. And there's also information on the CLE credits, which is, I know, very important to everyone. So thanks to Fredrikson for hosting us today. This beautiful office in downtown Minneapolis. And I say with confidence that we regularly refer our clients to Fredrikson. They are a full service law firm that can help you out in many ways. So thanks again.